God will punish you now and forever. Criminals. Any judgment, let it be on record. Any judgment going in this court is rubbish. Ask him, where is the law? Ask him what to show. Where is the law? Where is the law?
Welcome, dear friends. Nnamdi Kanu's judgment is ongoing currently. But before I show you the video of everything that's happening in court, I want you to understand that Nnamdi Kanu's home in Umuahia has now been surrounded by military personnel. From the video you are seeing, military personnel have surrounded the entirety of his surroundings.
And I went on to elucidate the body of objection and then the constitutional foundation and jurisdictional limits of this very court.
You all have the ground stated?
Yes, my lord, you may. Ground number one, my lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to ground two, my lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, Sub 1 of the 1999 Constitution, and no court has jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder, which is myself. The third ground, any order directing or implying a waiver or final address constitutes a breach of fair hearing, my lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number four, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number four, for reference purposes, my lord, Section 36(1) of the 1999 Constitution, which I'm sure the court has taken judicial notice of. Those are my grounds, my lord, in respect of the notice, seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very notice be adopted, my lord, in its entirety. The third and the very last one is the issue of bail, my lord, the issue of bail. This was dated the 17th day of November 2025 and filed on the 17th day of November 2025. It's a very simple one. It is a notice, my lord, brought pursuant to sections 35(1), 35(4), and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I am praying, my lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of the invalid charge presently before this court, an order, my lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence of a valid subsisting charge under a written law in force is unconstitutional, null and void, my Lord, and for any other orders that my noble Lord may deem fit to make under the circumstance. This is supported by an affidavit of 9 paragraphs deposed to by Prince Emmanuel Kanu, and also by a written address which I urge my Lord to accept its adoption, Honorable Lord.
Yes. You moved the 3 applications?
I have, my Lord.
Thank you.
Thank you.
The Prosecuting Counsel, can you react to those 3 applications?
May please, Your Lordship. The prosecution filed reply to the first motion on 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge Your Lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to are unknown to law. It is for Your Lordship to determine that in other ones. But the one asking for stay of proceedings, my Lord, our argument is to the fact that the statute does not permit Your Lordship to grant any stay of proceedings or injunction. So we urge Your Lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge Your Lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the count to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for Your Lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was... So we urge Your Lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter bill, the latter application with respect, is an abuse. In any event, none of them merits. We urge Your Lordship to dismiss it.
Please, let's save the time of the court.
We appeal Your Lordship to dismiss all the applications because they lack in merit and do not deserve any consideration at all. Thank you, my Lord.
Thank you, sir. Defendant, you have 1 or 2 words to say?
Thank you, my Lord, and I'm most grateful. My point is a very simple one, my Lord. Very, very simple. My charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my Lord. And very finally, I think it is very, very important that I allude to what my lords...
Please, defendants, at this point, you won't go and make references. I just ask you to reply on point of law.
It is, my Lord. I'm trying to explain exactly what the point of law is all about. We respect what he has just said.
Yes, let me hear the point of law.
My Lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you are here. Okpara is okay. Where are the others? Ejiofor? Where are the others? Yes, you just have 2 minutes for this. Yes. Yes, up 2 minutes for this.
Thank you, my Lord. I'm most grateful. Once again, I will start with the bail application that I made. Since he did not file any counter affidavit, my Lord, he is in effect conceding. And I expect that this very application should be determined based on the affidavit that I filed.
You may sit down.
And on the issue of stay, my Lord, once a matter borders on jurisdiction, stay can be granted. Once it is a jurisdictional matter, stay can be granted. What I'm asking for is for a referral, my Lord, to the appeal court for the determination of these very key issues. And also, I reiterate that AJA is not superior. It is not superior to the Constitution of this very country, and an established jurisprudence as determined by the Supreme Court that stays can be invoked insofar as the issue borders on jurisdiction. And my Lord, this is very, very critical. Not minding anything we may have said before, or I may have said, the fact of the matter is that the very count 7 laid under Criminal Code Act Cap C45, my Lord, is not Nigerian law. It doesn't exist. It just doesn't exist. Why should I be in detention over charges that don't even exist, my Lord? It doesn't.
You are exceeding the 2 minutes.
Okay.
Can you summarize?
Yes, please. I ask, my Lord, that I be granted bail on very favorable terms, given that a concurrent judgment of the Supreme Court of Nigeria determined, my Lord, and found that I did not jump bail. I never did. That was their finding. I did not jump bail. And that the revocation of my bail implied that.
It's okay.
Thank you, my Lord.
Thank you.
That's it.
You may sit down. I'm going to read extempore as the application and all before this court. The defendant filed 3 applications after the matter was adjourned to today for judgment. The defendant filed a motion on the 17th day of November 2025, seeking for 2 reliefs. 1, an order admitting the defendant's applicant to bail on liberal terms pending the determination of the invalid charge presently before this honorable court. The second relief is for an order declaring that the continued detention of the defendant applicant in the absence of a valid subsisting charge under written law in force is unconstitutional and void. The second application is the motion on notice dated and filed on the 12th day of November 2025, seeking for 2 reliefs. The first relief, as stated in this motion, is an order referring certain substantial constitutional questions arising in this trial to the Court of Appeal, pursuant to Section 295, Sub 2 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The second relief is an order staying further proceedings in the charge pending the determination of the referred questions by this court to Court of Appeal. The third motion has to do with the notification to file written address. As the defendant stated, he has put in his defense as his right to file written address should not be taken away from him. I've considered also the process is filed by the prosecution in reaction to some of the motions. In the application seeking to refer some questions to the Court of Appeal, the defendant submitted inter alia that the court cannot proceed to give judgment on a defective charge not founded on a written law. and that the court cannot rule on count 7 of the charge, contrary to the decision of the Supreme Court. I must say, most of the issues raised here in the application, save the application for bail, have been raised by the defendants severally in this court. And this court has made an order that all preliminary objections or issues shall be taken during the judgments. This court is bound by that order. However, the issue as regards to referral of questions to the Court of Appeal and the stay of proceedings. The statutory law governing criminal procedure in Nigeria, to its Administration of Criminal Justice Act 2015, by Section 306 of that Act, which provides that an application for stay of proceedings in respect of criminal matters before court shall not be entertained. These statutory provisions was initiated by the Court of Appeal in the case of Shuaibu versus Federal Republic of Nigeria. I must speak as to the essence, the reason for this statutory provision, that is Section 306 of Administration of Criminal Justice Act. The essence of this provision is to prevent inordinate delay through the filing of appeals while trial is going on. For this reason, the Section 306 of Administration of Criminal Justice Act have been provided that such application shall not be entertained. This court shall not entertain same. As regards to the application seeking for bail, we have different types of bail applications. Bail application can be bail pending trial or bail pending appeal. I've looked at the application for bail. This application before this court does not fall within those two classes of application for bail. In this matter, as also stated by the defendant, that he has put in his defense. Hearing has been concluded. And also, by the order of this court, on the 27th day of October 2025, the court made an order that the defendant should next date put in his defense, or if he's not putting his defense, he should file address which shall be deemed to be final address. The defendant's portion to that filed motion and comprehensive address. It is based on this that I hold that issues are relieved is highly unmeritorious. Same is hereby dismissed. Like I said earlier, all other issues have been raised to that motion and comprehensive final address that was deemed as final address, and another motion filed thereafter. This court, in the interest of justice, will not close its eyes to say the court will determine all this issue in its judgments. I proceed. I deliver my judgment. Judgment, please.
My Lord, I have an objection. Final written address is a constitutionally mandated right which I must be granted. It is in the constitution of this very country that final written addresses, my Lord, must be granted. I have not waived it, my Lord, and I insist that I address this court on all these issues. My Lord, do not forget.
The defendant,
my Lord,
consultant, can you tell your...
My Lord, I will not, please, let me finish. Please. It is my case.
I've gone...
It is my case, my Lord, let me finish. My Lord, this very court, another FAN was here, my Lord, another FAN said, at the one time we contradict and provide a piece of evidence. A piece of evidence given before the court. I need to write my private address, my Lord,
on the count charge which reads thus.
My Lord, I'm saying it clearly.
Defender,
I'm taking the private address.
Defender.
Show me, my Lord, you are conducting their case for them. You are the one running their case for them. Let them show me that the prosecution, show me where it says you can waive my right to final written address. And I'll sit down.
You have the right to appeal after my...
No, my Lord, this is a perversion of the cause of justice. This is not law. It is not law.
Can you excuse me?
My Lord, I cannot excuse nullity and illegality.
Can you let him
it's not possible. It is not possible, my Lord. You must show me where the Constitution says you have the right to waive my written address. You must show me.
Excuse him.
Show me. Show me where it says so. Show me. Show me where it says so.
Excuse him.
Is that why you brought the cameras? Is that why you brought them today?
Please.
You didn't bring it before. You brought it today?
Please.
Show me where it says you can try me on a repeat law. Show me.
Please.
Show me where it says you can try me on a repeat law. I said, show me. Show me.
Excuse.
Show me.
Get the microphone from him.
No, leave it. Leave it. Leave it. I said, leave it. It's a court of law. I'm under trial. I'm under trial, I have to speak. I'm under trial and I have to speak. Listen to me, please. I'm under trial. I'm under trial. I'm under trial. And I must address the court.
Please.
Wait. No, listen to me. Please. The judge must listen to me. No. Wait. I'm asking a very simple question.
Please.
No. Wait. Please. Look, this is Supreme Court. Wait, hold on. This is Supreme Court here. Hold on a second. Hold on. I said hold on.
Please.
May I inquire? This is not a court of law.
Please.
It's not a court of law. What you're doing is not law.
Please.
You don't know the law.
Please.
Show me. I said show me where you have the right to waive my right to final address. Show me. It's what the Constitution says. Show me. Show me. You cannot show me.
I'll come back.
You cannot show me.
Can you please?
You cannot show me because you don't know the law. You can't show me.
Alright.
Wait, hold on a second. Don't touch me. Don't you dare touch me. People who don't know law are starting over me. Show me where it says you can waive my right. Show me the place I'm asking you. Show me. Which law says you can try me an unwritten law? Show me. You cannot show me. And you're a judge. You claim you're a judge. You don't know law. You don't know law. Nonsense. Where is the final written address? Where is it? Which law gave you the right to waive my final written address? Which law gave you that right? Nonsense. You think I try this with you? You try with me? Of your man. What's this one doing here? What are you 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 doing here? This is the idiot that attacked me. This is the fool that attacked me. That's the idiot that attacked me. That's the fool. Don't touch me. Don't push me. I'm telling you, don't touch me. I'm warning you, don't touch me. I'm warning you, don't touch me. Don't touch me. Don't touch me. I said, don't touch me. Don't. Let him go by. Smart people. You don't know law. Show me where it says you can waive my right to final address. Show me the law. Show me the law. I want to show me the law. You don't know law. Let it be on record. Any judgment in this court is rubbish. God will punish you. Now and forever. Criminals. Any judgment, let it be on record. Any judgment in this court is rubbish. Ask him where is the law. Ask him what to show. Where is the law? Where is the law? Let's go.